Can a debt collector make false or misleading statements to try to collect on a debt I owe? Debt collectors may not lie when they are trying to collect a debt. For example, they may not falsely claim that they are attorneys or government representatives, falsely claim that you have committed a crime, falsely represent that they operate or work for a credit reporting company, misrepresent the amount you owe, indicate that papers they send you are legal forms if they are not, indicate that papers they send to you are not legal forms if they are. Let's face it, debt collectors have a bad reputation, and for the most part, they've earned it. There are very credible debt collection agencies and debt collectors that do follow the rules. However, when there is rampant abuse in a specific industry, you do need these warnings. You do need laws that protect your rights. Some of the most pernicious types of practices that are reported about debt collection abuse, they end up sometimes being news stories, are the types of lies that are told indicating that we're on the courthouse steps and we're about to file this lawsuit, we need a payment from you today, making statements that paying them will improve your credit report, saying things like you could be arrested, using foul and or abusive language. All of these items are collection abuses. Obviously, you have the ability to contact the authorities in your state and report abuse, consumer affairs departments typically, and also the Federal Trade Commission. You now have the opportunity to tell your story at the CFPB website. All of that can go a long way to curb abuse and establish recognized complaint patterns with a certain debt collector, collection agency, or debt buyer. But if you really are interested in pursuing protection of your rights, you typically want to engage the services of an attorney. And as I've suggested throughout this series on debt collection, you do have the ability to reach out to experienced attorneys who deal with collection violations as part of their normal practice, and do so at no cost, not for the consultation, and if they agree to take on your case, not for the case itself. Their fees typically are paid by the other party. So utilize the resources that you see on your screen, fill out the forms, get in contact with an attorney and talk about your particulars. One of the key things that I do want to establish is that we are specifically talking about debt collectors. One of the key things I want to point out is that I am talking about debt collectors, assignees, debt buyers, attorneys engaged in the collection of a debt, not your original creditor. So for example, you're late on a credit card payment, you've missed 2 billing cycles, it's been 60 days. Typically, you're still being contacted by phone and letter from your original creditor, either customer service or the internal recovery department. These topics don't typically apply to those kind of contacts. Just so you know, as maybe a time gauge, generally, original creditors are not going to assign out, especially when it comes to credit cards, usually within the first 90 days. And for a lot of creditors, they don't assign out or sell debt until they've charged off that account. Charge off typically happens at 180 days of consecutive non-payment. If you have more questions than have been answered about this specific topic, utilize the search function, go into our free community on DebtCC, and look for something similar to what's occurred with you. If you can't find it, please do start a thread, start a question using the Ask an Expert feature, and you'll get assistance. Remember, DebtCC is a free community. You get as much out of it as you put into it, so you have to become a participant. Let's move on to the next question.